learned counsel for the petitioner contends that as required by schedule attached to the ordinance, a copy of the eviction petition and the documents were duly annexed to the notice served upon the respondent, and this is so mentioned in the notice that there has never been any objection by the respondent that notice issued served was missing in copy annexures it has never been the case of the respondent before the rent tribunal when the application for condonation of delay was made, in the memorandum of appeal, no such ground has not been taken, therefore, the appellate form has transgressed beyond even the case of the respondent to grant him the relief, which is not available, full stop. New para. Here, there is no grounds of the respondent that the provisions of section 21/2 of the ordinance, were not complied with the petitioner and the notice received by him was lacking, the eviction application and or the documents annexed thereto, full stop. It is not the requirement of law that if the respondent of a case has not raised any objection in this regard, the rent tribunal shall necessarily specify in the order that the copies have been delivered, full stop. To the contrary, the respondent has set out the plea of misunderstanding and sought refuge under the stance that a litigant should not be knocked out on technical grounds, full stop. Therefore, the impugned order, which is not even in consonance with the case of respondent, is absolutely illegal and unlawful, full stop. New para. Anyhow, it requires to be examined if the time for filling the leave application could be condoned, suffice it to say that the period of 10 days has been prescribed by section 22(2) of the ordinance itself, with the consequence that in case the leave is not filled within the stipulated period, the tribunal shall pass the final order as per section 22 of the ordinance, full stop. This has made the noted provisions as mandatory as consequences of default are clearly provided, resultantly, the respondent was liable to the straightway ejected in term of the above quoted law, full stop. Whether the respondent is a willful defaulter in payment of rent, if so, at what rate and for what period, ? Relief, full stop. The case was adjourned for the evidence of the petitioner on 17/9/2008 on the above issues, full stop. Anyhow, the order of eviction was challenged by the respondent and the appellate form has concluded that as according to the provisions of section 21 of the ordinance, the notice shall be accompanied by the copy of application and the documents annexed with the application, thus it was the duty of the tribunal to give the copy of all the documents annexed with the ejectment petition, and detail of them must be incorporated in the order sheet, full stop. But the order sheet of the learned trial court is silent in this regard, full stop. When the requirement under section 21 of the ordinance has not been complied with, comma, so the question of the filling of leave to defend to petition under section 22 of the ordinance arises subsequently, full stop. In these circumstances, in this case, the requirement of section 21 of the ordinance does not seem to have been fulfilled by the learned rent tribunal, comma, therefore, comma, impugned order is not sustainable, full stop.